All right, sports fans. Today's topic of conversation in the fast-paced and sexy world of commercial insurance is going to be executive protection. Executive protection includes what Michael just listed: directors and officers, employment practices liability, also known as EPLI, professional liability, and crime or employee dishonesty insurance. In this episode, number 4 of the Financial Poise series, Insurance for the Business Owner 101, we're going to cover the basic legal contracts for these kinds of insurances. We're going to explain some basic terminology and discuss what provisions usually can and cannot be negotiated. So, to learn more about Financial Poise, you can view slide 37 or 36, excuse me. Our panelists today are Lee Burke of Burke, Bogart, and Brownell, Jonathan Mayotte of Thornton Powell, and Bradley Dlatt, formerly with Reed Smith, Perkins & Coy. My name is Gary Kirschenbaum. I'm with the Alera Group, and I'll be your moderator today. This webinar is delivered in plain English, understandable to you, even if you don't have a background in the subject. The idea is that we can bring you into an engaging, sometimes maybe humorous, if we're good, conversation designed to entertain along as it teaches. It's specifically designed to be viewed as a standalone webinar, meaning you do not have to view the other episodes in the series in order to get a lot out of this. Now, neither Financial Poise nor we intend this to be an infomercial, so you're not reading bios about us. If you really want any more information on us, you can see that at slides 30 through 33. Now, about the slides. I'll try to call your attention to slides and move them along as they're relevant to whatever it is we're talking about, so you can take notes if you like. If you're only listening and not watching, don't worry about it. You'll be fine. The slides are not critical. And copies can be obtained through Financial Poise. Our webinars are supported in part by sponsors. This particular webinar is supported by Max Asset. If you need to conduct an online auction, Max Asset is your turnkey provider. And then also another sponsor for us today is the National Law Review, and also our co-producer. All right, last thing before we begin. Slide number 5, the disclaimer. You are not our clients, and we are not your lawyers. And heck, Jonathan and I aren't even attorneys at all to begin with. We're here today for your general education and not for you to act on without appropriate advice. And wow, bad timing. Get rid of that. Sorry. Without further ado, here we go. All right, topics that we're covering today, which we've already labeled or identified: professional liability, directors and officers, employment practices, and crime. It's a lot to cover, even at a high level. So let's dive right in here. Tackling professional liability first. In a prior session of this webinar, we have talked about general liability. So to start us off, Lee, if you will, give us an overview of the risks that a professional liability policy is intended to cover and how that will differ from general liability.
Okay, thank you, Gary. Professional liability insurance of any type is intended to protect the business owner and its employees, executives, etc., from the liability arising out of the failure to meet or to adhere to professional standards. And I emphasize professional standards. Professional liability is dealing with a standard of care. It's what we could have done, what we should have done, what we did wrong, what we could have done differently. Think about it as being a performance grade on how you did as a professional. And professional liability is dealing with either errors of omission or errors of commission. So sometimes the things that you didn't do in a professional liability situation are as important or more important as the things you might have done wrong. Um, that differs from general liability in the sense that general liability is designed to cover the bodily injury, property damage, or perhaps personal injury liability exposures arising out of your business activities, the services you provide, the products you sell, the activities that you carry on in a daily business activity format. And claims arising from general liability tend to be of an accident nature, something very distinct, something sharp happened that was unexpected. Again, as opposed to professional liability, which is a meeting of professional standards, an excellence of care.
Excellent. Excellent. Thank you. And adding to that, Bradley, from your experience, because I find a lot of times it's business owners have some misconceptions about what professional liability is. Maybe you can give us an idea of what you've seen with business owners and respect to professional liabilities and their misunderstandings or misconceptions.
Yeah, absolutely, Gary. And I think Lee hit the nail on the head in calling it. You often hear professional liability insurance called errors and omissions insurance, or E&O. I think about it as malpractice insurance as an attorney. What it's meant to cover is a broad swath of claims related to specified services that one person or one business provides to another person or another business. What's important about these policies, and the reason not everyone needs a professional liability policy, is that the key language in the policy where the rubber meets the road is the definition of a professional service. Some policies don't define it, but a general understanding in the industry is that a professional service is a service that requires specialized expertise or training or is knowledge based. So, for example, professional service would be an attorney, an accountant, a consultant, someone who's being paid to provide some sort of advice for which not that the average Joe off the street couldn't do it. It requires some level of specialized training or expertise. And what's important, I would say, is that these policies are negotiated up front to have a defined scope of what professional services is or isn't. So if you're a business that's doing something specialized for clients, a professional service liability policy may make sense. If you're in a position where you have a narrow universe of services that you provide and you want to make sure your policy is specifically written to cover claims arising from those services. And the types of claims that we see, as Lee pointed out, involve really kind of three buckets. One is your advice fell short of what you promised it would do. One is that you failed. Another is that you failed to complete the tasks that you were hired to complete. And a third is just that the advice led to bad outcomes. You provided bad advice. Those are the general contours of what we see for professional liability insurance.
Got it. Got it. Okay. And then, so within the context of these policies, professional liability, E&O, malpractice, all really the same thing, depending upon the industry we're talking about, right? Jonathan, one of the things that we as insurance folks often talk about is claims made policies, right? And claims made applies to professional liability policies. Can you break down what claims made means and what the specifically, and most important, what's the implication to a business owner?
Sure. So if we're going to talk about claims made policy, I think we also need to briefly touch on occurrence policies so we can kind of show the difference of them. So I'll start with occurrence. An occurrence policy is pretty much going to be your general liability policy, an umbrella, maybe a commercial auto policy. The best example I can give you is if you had a policy that was enforced from, say, 10/23 of 24 to 10/23 of 25, and then you canceled it, and then somebody came back later and sued you for something, say, on 6/1 of 25 that occurred during that time. Since you had coverage in place at that time, you have coverage. Now, if you have a claims made policy and that same scenario comes up, you have no coverage if you let that policy cancel, unless you purchase an extended reporting period endorsement or tail coverage. Something to be very aware of. There's something on claims made policies called a retroactive date or an anniversary date. If you are switching carriers, you need to make sure that that lines up to what you've had on your prior policy. Otherwise, you may have a situation where a claim could arise and you may not have coverage. So things that you need to make sure that you're asking about, asking your agent about. But back to the tail coverage, the way that usually works is that if you're canceling the policy for any reason, mostly what you're going to be doing is deciding between a 1-year tail, maybe 3, 4, 5-year tail, depending on what your needs are. You're going to need to pay all that premium up front because the policy is being canceled, and it's going to be a percentage of what the expiring premium is. So that's kind of claims made policy in a nutshell.
Got it. And so I don't want to mislead anybody that's listening in. It's not like tail coverage is needed on a regular basis. Like if I'm got a policy for professional liability and I'm just moving from one carrier to another, for instance.
As long as you're able to match up the retroactive date and the coverages line up, then you do not need to purchase the tail. If you're say retiring, closing a business, selling the business, that's typically when tail coverage is going to be needed.
Got it. All right. I have this next question here, and I don't even like the way it's worded, so I'm going to try and rephrase it. But it refers to the policy period and the extended reporting periods. But Lee, when it comes to noticing the carrier for a claim, right? And there's different types of noticing. There's notice only, there's notice of circumstances, there's also a notice for record purposes only. Can you walk through at a high level what these are, what the meaning of this is, and how reporting a claim, and this would really apply to most any policy, but specific to professional liability, how reporting a claim for a policy holder, an insured, might impact their premium?
Okay, thank you. You're touching base on a real landmine area in the insurance world. So thanks for dropping the landmine in my lap. Claims reporting is an essential part of the obligation of the policyholder, and I want to emphasize that it is an obligation of the policyholder to be able to collect and properly receive the benefits of an insurance policy. Virtually every insurance policy, whether it be a property insurance policy or a liability insurance policy of any type, is going to have a provision requiring the policyholder to notify the insurance company in the event of a claim or the expectation of a claim, when something happens. And the principal reason for that is that you've paid a premium, and once a potential claim happens, the obligation to defend that claim, pay the legal expenses, etc., and pay the damages for that claim belong to the insurance company. So you are basically at that point playing with the insurance company's money. And as the policyholder, if you make a mistake and that mistake ends up costing the insurance company thousands or potentially tens of thousands of dollars in a claim payment, the insurance company is going to lose their sense of humor. And we all know that insurance companies don't have much of a sense of humor to start with. So it is very, very important to meet that obligation to notify the insurance company. Now,
but Lee, if I have let's say I'm an insurance agent and a client makes a claim that we did something wrong, which would arguably be something that falls under our errors and omissions or professional liability policy, but it's a little thing and we know we didn't really do that. Do I really want to tell my insurance company and risk having that on my record?
oh, absolutely, positively not. None of us do. We want to all play the see no evil, do no evil, hear no evil routine, because we're afraid that our policy might get non-renewed, it might get canceled, the premiums might go up. We get a black mark somewhere in our history. So it's human nature not to want to address negative events, and a claim is a negative event. Again, we have to balance that off with the obligations of the policy. And this is an area, probably as much as any area in the insurance world, where the advice and the counsel of a good professional insurance broker or agent or risk manager becomes invaluable. Because there are many ways to communicate to an insurance company that an event has happened. You can make a formal claim, and they can open a file in the case of a liability claim, maybe bring in attorneys. And that's going to probably have some negative consequences to the policyholder downstream. It's going to affect renewals or premiums or the availability of coverage. But you can also document certain things to the insurance company. There are plenty of ways of, I'm going to call it soft selling, and I don't mean that in a negative context, but there are ways of meeting that policy obligation to the insurance company without necessarily falling through the trap door into oblivion. And one of them simply is notifying your agent or broker. Keep in mind that in a situation where you're dealing with a true agent, that agent is a representative of the insurance company. And when you notify the agent, you've notified the insurance company. Now, the agent may or may not notify the insurance company. That becomes their problem. You just put the monkey on their back. But once you've sent that email, and by the way, do everything in writing. Once you've sent that email or documented the phone call, the responsibility becomes the agent. And they're going to want to work in your best interest. So there are many ways to skin the proverbial cat on claims.
So, and I haven't really been asking, but Jonathan, Bradley, anything to add on? Because Lee's right, reporting claims, big topic in our world, right? How and when and so forth. Anything to add?
Sure, happy to jump in. I've spent the last 9 years litigating coverage disputes on behalf of businesses against carriers all across the country. And these issues come up repeatedly about when was a claim, capital C defined term in a policy, made? When was it reported? And if so, if it was reported later than it should have been, is there coverage? Because insurers all take the position that reporting a claim under a professional liability policy is a condition to getting coverage, as Lee was saying.
Right.
What's important to know here, if I'm the average Joe business owner, or I'm a generalist attorney who doesn't do a lot of insurance work, but all my clients have insurance, capital C claim in a policy like the ones we're talking about today is unbelievably broadly defined. Capital C claim can be anything that involves a demand for monetary or non-monetary relief. That's the standard industry language. So that means if your client or your company gets an email from somebody saying, hey, you need to pay me X, or you need to do Y because of these reasons, that can be enough to trigger a reporting obligation under an insurance policy. And oftentimes what we see is there'll be an email exchange, or there'll have been a letter sent by an attorney, and the client says, oh, I don't want to report that because I don't want my premiums to go up. I don't want to deal with it. It's a nothing. And then there's a lawsuit that gets filed 2 years later. The insurer turns around and says, oh no, the claim, capital C, was made 2 years ago when you received that letter that you filed away and did nothing about. So you have no coverage under our policy 2 years later. We're not responsible for that period. So understanding what a claim is and when to report it is critical. And I would say agents, brokers, or even outside attorneys can give you the advice you need to make sure that you're meeting the reporting requirements. It's the easiest way to lose coverage.
Got it. Excellent. Staying with claims, and I'm going to direct this to you, Bradley, because you are our attorney on the panel. And I noted that Jonathan and I are not attorneys, and I forgot Lee. Sorry, didn't mean to leave you out there. Lee is also not an attorney.
Thank you. I thought I was getting painted with a black brush there, but
Yeah,
I
no, you're
appreciate the
good.
escape clause.
You're good. But Bradley, as our attorney, and this is very true, I know, with attorneys, but it would apply to accountants, insurance professional, anybody who would fall under the classification of needing a professional liability policy. When professionals are not paid by their clients, and I know there's a lot of hesitations in the legal field around suing a client for payment. But sometimes in order to get paid, that might be your only choice. And when that happens, often there's a counterclaim, right, from the client. And the counterclaim asserts that not only does the client not owe anything more for the services rendered, but that what was already paid needs to be paid back because of claim of malpractice of some sort or another. How does that get handled under a professional liability policy?
So that situation, Gary, ties back into what I was just talking about, that the definition of capital C claim in most professional liability policies is super broad. And as a result, that counterclaim, even though it was triggered by your own collections action, turns into its own capital C claim under the insurance policy and needs to be reported to the carrier. What happens from there often depends on what's been alleged, because the way professional liability policies work, which is different from a general liability policy, is they pay for loss, which is a capital L defined term. And what the carrier pays or doesn't pay is going to depend on how the carrier defines loss. That's different, for example, from a general liability policy where the policy pays for damages, which is a different term and typically not defined. And under loss, most policies include settlements, they include damages, they'll include attorney's fees. But what they won't include is items that are not insurable by law, or things like fines or statutory penalties. And where this gets interesting is when you get into cases where the counterclaim saying that I not only do I not owe you any more money, but you owe me money back because you provided bad advice. It depends what's alleged, because if the allegation is that you committed a fraud, for example, or the allegation is that you stole from me as a professional providing me a service or not providing me a service, then you get into exclusionary territory. The key case on this is the Level 3 communications against Federal Insurance Company, which was a 2001 decision out of the Seventh Circuit Court of Appeals by Judge Richard Posner. Judge Posner is probably the most famous non-Supreme Court justice in American legal history. Very, very well respected. And what Posner said in Level 3 is that basically a return of an ill-gotten gain is not insurable. That's not damages. That's not a loss. What it is your counterparty is saying that you've been stolen from, that they've stolen from you. That's not insurable. So the question becomes, in this claim where the party's trying to get their fees back, is the allegation that you stole from me or these fees were ill-gotten, such that they are basically being ordered to pay restitution, or are they true legal damages? And that's really where the line is drawn when it comes to coverage.
Got it. Mind your P's and Q's as a professional, is what I'm hearing. All right. So one other element of professional liability policies, and I think that this is usually a fairly, I won't say obvious, but known thing, if you will, about these policies. But Jonathan, let's just enlighten our audience a little bit about intentional acts and claims of fraud under a professional liability policy.
Yeah, so general rule of thumb with any insurance policy is that it's not going to cover illegal acts. So claims involving intentional acts and fraud, they're typically going to be excluded from a professional liability policy. Professional liability policies, as we mentioned, they're designed to cover negligent acts, errors or omissions, but not intentional wrongdoing. But there are a few nuances out there. There's severability clauses that you can find in policies that allow other innocent insureds to retain coverage if, say, one insured commits fraud, and also depends on how the policy is written. So something to ask your agent about. Defense under reservation of rights that could allow insurers to defend a claim initially, but it also would reserve the right to withdraw coverage if facts are shown that there was fraud or intent to commit fraud. And then final adjudication requirement is another one that many policies will require final adjudication of fraud or a court judgment before denying the coverage. So I think I actually did see that one time with a client where they went through and then they decided, oh, you know what? No, there were some things that were not above board, and then the insurance carrier went back after the insured. So those would be the nuances when it comes to fraud being covered, but in general, no, not covered.
Gotcha.
Can I make one observation, Gary, before we move on? This is a quick one.
Yeah.
Most plaintiffs' attorneys love to allege fraud, and they love to allege intentional wrongdoing. Why? Because they want to get punitive damages. That's a big number. That's a way to really make an opposing party pay. So oftentimes what you see lawsuits that will allege negligence or some lesser conduct, an error or an omission, and intentional acts and fraud. Those mixed cases are ones where you really need to rely on a great broker or a great attorney for advice, because insurers will try to deny those when they should be covered. Because the typical standard when it comes to, am I entitled to a defense, is there any allegation in the lawsuit that's potentially covered? And so in those mixed cases, you really need to be proactive in trying to seek coverage from a carrier, even where there might be some part of the lawsuit that's excluded.
Good point. We're often asked questions like, well, will that policy cover this claim? And the answer is we get to pretend like we're attorneys and say, well, it depends. How is the claim brought? How is the claim written? And then we'll know. So predicting whether a claim will be covered or not can be very difficult for that reason. Interesting. All right. So we talked about a lot of different types of professional liability policies, and even some other ones. There's, manufacturers' professional liability is another type of policy that's out there for certain types of manufacturing that's done, media. And another one that's very, very popular these days, cyber tech E&O, or cyber tech errors and omissions. Not applicable to all companies, but certainly applicable to companies that are hosting, creating software, supporting other companies' systems. And when they have cyber tech E&O, Lee, we've talked about cyber liability in previous episodes. Have you seen instances where the cyber issues, not under tech E&O, but cyber issues under a regular cyber liability policy, can cross over with a professional liability policy?
Yes, and one of the main areas when you've got cyber liability coverage if you have a cyber event, it is very, very likely that there are going to be a wide variety of regulatory requirements that are imposed, dealing with credit issues, dealing with regulatory issues, dealing with privacy issues. There are going to be notifications. You may have to provide services to the potential injured parties that have been possible victims of the cyber event. And that may very well then coincide or have impact on the professional liability policy. And this becomes one of the many reasons why it's very, very important for most clients to be dealing with one broker or one agent and be securing all of their coverages from a single broker or agent, so that agent and broker can coordinate the advice and the counsel and the information of the client and the claims assistance. And they know what's going on. If you've got a client buying 5 different types of policies from 5 different agents, inevitably somebody doesn't get told something and things fall through the cracks. That
Right.
happens all the time. So deal with one agent. Again, be proactive in notification. Be proactive in picking up the phone and calling and saying, we had this event. What do we do next? Let the professional agent risk manager advise you when and how to notify the insurance company, when and how to discuss with legal counsel, and all of the steps that need to be taken to address that claim in a proactive manner, because it's probably going to involve several different policies.
Yeah, one example I know of, a company was breached, data from their systems was stolen, and it was customer data that they had in their system. So the cyber policy, of course, responded to the breach. The problem was that the customers, one particular, claimed that they were suffering a loss as a result of this company's inability to protect the data, and that was a claim against their directors and officers, not necessarily their professional liability. But these policies, these claims, excuse me, can cross over from policy. You know, there can be multiple policies responding to a claim. And your point is really well taken that you really should consolidate who you're working with. Pick somebody, pick a horse for the race, right?
You know, pick a horse for a race, or please don't put three jockeys on the same horse. That doesn't work. Yeah.
Right. So, and that's a good segue I created for myself there to jump from our professional liability to directors and officers. And I also want to point out, not too long ago, I had asked the question about, misconceptions that business owners have. And this is one that I see a lot. Somebody will be asking me a question and they'll say, they'll be asking a question about E&O and I'll have a hard time following the question because what they're actually asking me about is D&O, but they get confused. And so I think it's important sometimes for us as professionals to make sure we're listening close enough to understand what the client may mean versus what they might actually be saying. And but so turning to D&O, directors and officers liability insurance. And I haven't been diligent here on the slides, so I'll do a little better. Bradley, I'll direct this one at you. For business owners who historically haven't purchased D&O, which for a lot of small, medium-sized, privately held companies, that is not uncommon. What would be the key reasons as to why they should be looking at this insurance and obtaining it?
So this is a great question, Gary, because I have dealt with many startups in the last few years where there have been situations that a D&O policy would have responded to, or a better D&O policy would have saved the client literally hundreds of thousands of dollars. D&O insurance at its core is insurance for the company's business judgment. Any claim that comes from a customer, from a shareholder, from an investor, from a business partner, making an allegation that either an individual within the company or the company itself made some judgment-based mistake triggers D&O coverage. And so that's different than an E&O policy where you're talking about professional services. Here, we're talking strictly about business judgment. And the most valuable part, and I know Jonathan's about to jump into this, so I won't steal his thunder, but the most valuable part of a D&O policy is that it protects employees, directors, and officers individually, even if the company is not going to protect them. So if I'm a business owner, this is the first policy I'm buying because this protects me as a person if somebody tries to come after me individually for decisions I made while running my business. To me, D&O insurance is essential. I had a startup client recently where their customer decided to misuse their product and got into some criminal trouble. And so my client had to spend hundreds of thousands of dollars on counsel because their product was what was at issue, even though they didn't do anything wrong. The D&O insurance came in and paid for that cost. Without D&O insurance, they may not be operating anymore because the legal fees were absolutely crushing to respond.
I think that's a really good point, and I like the example because I think most people think of directors and officers. First of all, they think of it in terms of public companies, and they think of it as suits coming from shareholders. It's become common enough, particularly with startups, but even in the M&A world where there's outside or passive investors, we also think about directors and officers because there's people that can make those claims. But I don't think a lot of companies realize even customers and suppliers can make claims that would be covered under a directors and officers policy for some of the reasons that you've put out there. So that's really good. And you're right. I'm turning to Jonathan next to talk about some of the terminology that we hear with D&O policies and really specifically, side A, side B, and side C.
So
what does that mean?
Side A is basically what Bradley was talking about just a second ago when it comes to protecting directors, officers, employees. It's going to protect them, when the company cannot pay for defense costs or settlements, or is not going to pay for defense costs and settlements. A lot of people serve on nonprofit boards. If you're on a nonprofit board, that side A coverage is very, very important to you because otherwise, without that D&O coverage, if somebody comes back and names you in a lawsuit for something that occurred as you're acting as a board member, working for free, essentially volunteering, risking your personal assets. So something to keep in mind. Side B reimburses the company for payments that it makes to indemnify directors and officers. And then side C is going to cover the company's own liability, typically for securities claims in public companies. So that's side A, side B, and side C in a nutshell.
Got it. I would add, well, I won't add. I would ask Lee, Bradley, any of you guys, either of you want to add anything to that?
I would say maybe the only thing worth noting, I thought Jonathan's summary was perfect. When it comes to side C, the entity coverage, whether the entity is public or private, usually it depends on what the scope of the coverage will be offered. So like Jonathan was saying, for a public entity, it's typically limited just to shareholder claims or securities related claims. But for a private company, D&O coverage for the entity is very broad. It's almost in that way like E&O coverage, where you're talking about any sort of mistake that's alleged, error or omission related to the running of the business can trigger side C for a private company D&O policy.
Got it. Got it. You know, one of the things I would point out is that side A, where the company doesn't reimburse, you know, there's a lot of lawsuits that follow in the event of a bankruptcy. And if you're on the board of a company, you want that side A coverage in place, because if there's a bankruptcy, there's now no money left to pay for a claim that might come in against you. And that's where it can be really critical. All right, so moving on, Lee, let's talk about who's covered by a D&O policy, because, you know, we say directors and officers of the company. And let's look at, like, for instance, a bank where everybody's a vice president. Are they all covered by a directors and officers policy? Are they all considered officers?
One of the most important parts of a D&O policy are the definitions, and particularly who is covered. And this is an area where there's a reasonable amount of flexibility to negotiate with underwriters through an addendum to a policy or a clarification on who is covered. You're right. Industries like banks tend to give everybody a title. A lot cheaper to give somebody a title and new business cards than just to pay them. And in theory, yes, are they officers? Well, that depends. A lot of carriers in a lot of situations, insurance companies take the position that if you're in the state, the Secretary of State's corporate records as a corporate officer, then you're a corporate officer. That doesn't include the 814 assistant vice presidents of the flower bits at a bank. But the D&O policy is designed to cover people that are making decisions, impacting decisions, setting policies. So that is your executive officers, it's your C-suite, it's your senior managers, it's your officers and directors. But sometimes there are important financial committees, advisory committees, et cetera. And you can extend a D&O policy to cover, and it can be extended to cover employees in theory, if you can get the underwriter to do it. And underwriters, you can give them a reasonable reason, they will often extend the D&O policy to people who do have decision-making capacity or decision-making influence. So basically that's who you want to cover. You don't need to cover a janitor in a company and a D&O policy. But if you've got a vice president of janitorial services for a huge property manager and they're making $1 million purchase decisions, that's a different situation.
Right.
So this is an area that, again, the help of the broker, your risk manager, your agent, negotiating with an underwriter can be very, very helpful.
Right.
And again, you mentioned nonprofits. Nonprofits want to cover their volunteers. A lot of nonprofits, my own personal opinion with my clients is don't be on a board of any nonprofit. All you can do is get sued. Be on some type of voluntary committee that may advise them but has no actual authority. So there's lots of ways to try to skin the cat.
Got it. All right. And so, Bradley, we just talked about the professional liability policies, and I had made mention of the confusion sometimes that occurs between E&O and D&O. Is there an overlap between these policies? Like, how should a business owner be thinking about, these policies and what liabilities are being covered?
There's definitely an overlap in that when a case is alleged, when someone has made a claim against the business or against individuals that run the business, there are oftentimes open questions as to really what the allegation is targeting. So, for example, is the allegation targeting services that the business was providing, or is it targeting the business judgment of the business? That's really where the line is drawn. I would say oftentimes if I'm given a claim that could trigger both an E&O and a D&O policy, my advice to a client is to advise both carriers. And you often see them sold together as a management liability package policy, particularly if you're a smaller business. That's the way to go, is you can get an E&O, a D&O, and typically an EPLI all as one package. And often there's shared limits. So even if you're not going to get coverage under one line, you may get coverage under the other. And then as the claim evolves, we start to determine it through an iterative process with the carrier, does this involve professional services as defined or not? If it's professional services, it goes to the E&O. If it's not, it sticks under the D&O. I will say I've actually had cases where both have been triggered. For example, D&O policies will exclude professional services to send those claims to E&O policies. But those exclusions may have carvebacks where the professional services were performed by an agent. So, for example, I've had real estate developers who hire property managers, and they've gotten sued by tenants, and the tenants are claiming that you mismanaged the property. That claim can actually trigger both, because the professional services weren't actually being performed by the insured. They were being performed by a third party who they hired. And in that situation, you get the best of both worlds. You get the benefit of both policy towers.
Got it. Excellent. So you mentioned that they sometimes can be packaged together, and we're talking about the executive lines package here. So one more line that gets packaged in with this would be what's referred to as Employment Practices Liability Insurance, a mouthful, or commonly known as EPLI insurance. And when we talk about it in the industry, so for understanding, EPLI insurance is coverage for the business for claims of things like harassment, discrimination, wrongful termination, sexual assault, all the fun things that employers can sometimes be subject to, and reminding everybody that you don't actually have to do anything wrong in order to be accused of doing something wrong and having to defend yourself, which often these policies are really defense money. So let's talk about that, Jonathan, and let's talk about the difference. Sorry, I got myself lost in where I was. Oh, I think I just kind of answered the question, but Jonathan, delve a little deeper into EPLI and what it's covering for employers.
Sure. So, yes, it is a mouthful, which is why we all refer to it as EPL or EPLI. As Gary had mentioned, it's going to protect employers from financial losses that are resulting from lawsuits that are filed by employees, former employees, even job applicants. There's suits that typically allege wrongful acts related to employment processes, claims involving discrimination, wrongful termination, sexual harassment, retaliation, failure to promote, invasion of privacy, defamation, negligent evaluation. The one thing that I think a lot of people don't realize is job applicants have that ability to sue you as well under this policy, which is why it's very, very important when you're hiring somebody to be very careful about the questions you're asking, what's on the application. Make sure you have an HR person or an employment law attorney review what you're doing before you actually go through and start the interview process or anything like that, just to kind of cover your bases. But the policy is going to cover the company, the directors and officers, managers, employees, independent contractors, and seasonal or leased employees. And then also coverage can extend to third-party vendors. So say a third-party vendor comes in and says that, one of the employees was maybe making some advances that they didn't like or something like that, and tries to sue the company and say, hey, you guys made me feel uncomfortable when I was in there. Your policy can pick that up. That's something that not all policies will pick up, but something that can be picked up under certain policies. So another question to ask your agent whether or not that's covered.
So you're suggesting that maybe business owners read their policies?
They should always read their policies. Do
Okay.
they? No, we know the answer to that, but
Right.
yes, always read your policy. That's very smart.
But these are good questions to ask, and
Absolutely.
uh, professionals that are advising business owners should be asking these similar questions. Employment status, to understand, as an example, to understand whether or not are they covered properly.
Yes.
What do they need to do in order to get coverage in place properly? Okay. What would be, Lee, what would be the common exclusion? EPLI, I think they have, oh, there's always exclusions in every policy, right? But what are the common ones that you would see with EPLI?
One of the most common ones, Gary, that people immediately think of, and one of the most common claims dealing with employees are wage and hour issues. Somebody's not getting paid overtime. They're not getting paid the right amount. They're not getting paid in accordance with agreements. With state statutes or county statutes on how somebody's supposed to get paid, or withholding issues. So the whole area of wage and hour is pretty much excluded under an EPLI policy. EPLI is not intended to cover whether somebody's getting paid fairly. It's intended to cover other types of discrimination or employee abuse or misfeasance. There are a number of other areas of insurance that deal with insurance that deal with employees. So a lot of the exclusions would be for items that will be covered elsewhere. For instance, ERISA. If you've got an ERISA claim, you're dealing with ERISA liability. If it's a claim dealing with a management of employee benefit program, you've got employee benefit liability insurance, which could be purchased. So there are exclusions for that reason. Claims dealing with fraud, workers' compensation, picked up under a workers' compensation policy. Loss of tangible property. If an employee had tangible property that was damaged or stolen at work, that's not going to be covered. That's not part of an EPLI policy. Claims arising out of sickness or disease or pollution are not covered. So those are some of the most common types of things that would not be covered by an EPLI policy.
What about third party? So a company has a salesperson that's going on site to customers, and he's likes the receptionist at the customer and is a little too forward, and then there's a claim from the other company now.
Yes.
Could be a third party. What does that look like?
You touch base on two interesting things. An EPLI policy can be endorsed to cover third-party liability. So this would be a claim basically from the public back against your company or one of your employees for some form of harassment, sexual discrimination, sexual harassment, abuse, etc. So that's a third-party extension, which is very, very important for a lot of companies.
But to point out what you're saying is that it's an endorsement, meaning that it's not necessarily a part of every policy.
It is not necessarily covered. You have to extend that coverage to that third party, basically the public bringing you, a claim against your company for that type of aberrant employee behavior, if you want. Kind of goes along with that. Everybody in the insurance business, we all laugh and we all know about the fact that really nobody has employees anymore. They just have independent contractors. Everybody's got independent contractors. Doesn't care what the law says. Clients always want to call them independent contractors. Well, an EPLI policy is generally not going to bring what would normally be a covered claim from somebody that is an independent contractor. So your independent contractor that is claiming that they've been abused or harassed or anything is not going to be covered under your EPLI policy. Why? Because they're not an employee. Right. So you be careful who you call an independent contractor. You might be opening the back door to an uncovered insurance claim.
And Bradley, another one of the exclusions that we see, and see them all over the country, but in Illinois, it's particularly problematic due to some of the laws here in this state. But talk about BIPA, what it is and the exclusion. And well, go ahead, please.
Sure. I've written and presented extensively on BIPA coverage or data and other data privacy related coverage. For the uninitiated, BIPA is the Illinois Biometric Information Privacy Act. And what it does is the act creates a civil offense for businesses that collect a person's biometric identifiers or biometric information without obtaining proper consents or making proper disclosures or having proper policies in place, and also creates a cause of action for companies that use that information, biometric information, improperly. There have been thousands of lawsuits filed under BIPA. There are several states that have copycat laws that are starting to come through. The city of New York at one point had an ordinance that was very similar. What's unique about Illinois is that there's a private right of action. There have been, as I said, thousands of lawsuits. The damages of some of these early lawsuits were in the tens or hundreds of millions of dollars, because initially the statute was read to mean that each moment of collection was its own offense. So if you are a company that uses a thumbprint scanner to do time cards, for example, every single scan would be construed as its own offense. Illinois recently amended the statute to kind of close that loophole after some guidance from the Supreme Court. But for the first 8 years or so that BIPA was in existence and that it was being litigated, the damages in these cases were huge. And many times the plaintiffs were employees. They were individuals that said, I worked at your restaurant or I worked in your business and you had a thumbprint scanner or a retinal scanner, and we're collecting my data without consent. And as a result, we saw thousands of class actions being filed by employees of companies for violations of BIPA. And there's a statutory minimum of $1,000 fine for each violation. So these add up very quickly. Many EPLI insurers have started adding exclusions specifically for BIPA in their policies. But if you have claims that predate these kind of broad exclusions, you may still have coverage, because these really were textbook EPLI claims saying that you were violating an employee's right to privacy by collecting their data without making the right disclosures.
Yeah. And we could talk about BIPA for another hour if we wanted to, especially in this state. But I want to move on because we're running out of time, and I want to touch on our last line, which is crime or employee dishonesty. And Lee, if you would give us an overview of, what is this that we're talking about? What kind of crime? Employee dishonesty. What does that really mean?
Well, crime insurance policies can have a wide variety of coverages. But the specific one we're talking about today is employee dishonesty, otherwise referred to as employee fidelity or an employee fidelity bond. It is basically the theft of assets. Could be cash, could be inventory, could be other types of assets from a company by an employee or employees acting in collusion. And this can be very, very important. What people don't realize is that most employees don't steal large amounts at any specific given time. They steal relatively small amounts or moderate amounts over a long period of time. But that amounts up to a great deal of money. One of the great claims that I heard of was the Doral Golf and Resort Complex in Miami, where one of the green superintendents was an employee for many, many years. And this is I think 54, 72 hole golf complex plus hotels and resorts and everything else. And basically one of the responsibilities he had was ordering all the landscaping, the trees, the shrubs, and the flowers and everything else. Well, in the front gate would come 20,000 trees and plants and shrubs every year, and out the back gate would go 5 or 6 or 7,000 somewhere else. And who the heck was keeping inventory for all the trees and shrubs and everything else over 600 acres? Nobody. Well, over a long period of time, that was a lot of trees and shrubs and money. And that happens, and unfortunately happens in business. It's hard keeping track of everything. So employee dishonesty coverage can be very important. One of the problems is there were also very, very difficult claims to adjust, because they do happen over large periods of time, and they happen over over a wide variety of items and, inventory controls, et cetera. So I hope that, that helps.
I think it does. I think it does. So Bradley, employees can be tricked into giving property or money away. Social engineering is a term that I think everybody is probably familiar with. Um, how's that addressed with a crime policy?
So as Lee said from the get-go, crime policies can be very broad and often are pretty bespoke to what a business expects in terms of risks. So it is now to the point that this has become so prevalent that you can buy specific social engineering coverage within a crime policy. And in many ways, it's like the old days of check fraud, where someone would come in with a fraudulent check and hand it to a bank, and the bank would cash it, thinking that it was a correct check, even though there were problems. Nowadays, the fraudulent check is an email link that they need to click, and somebody puts it in the banking information because they pretend to be a client or a counterpart. And typically, those losses can be covered by a crime policy. I will say they are hard claims to pursue, and they need to be pursued really diligently, because the insurer all along the way is going to be looking for evidence of fraud, for evidence that the company set this up to try to get a payment. And the same is true with employee dishonesty. I've handled a number of employee dishonesty claims, employee theft, the beloved HR person who spent 20 years secretly stealing from the company by writing checks to PO boxes for services that they never received. I've seen many of these. And the key with these is to be really, really diligent about documenting them. And oftentimes it can be helpful to get your broker and to get your counsel involved early. So that way they can walk you through the process and you avoid the obvious kind of pitfalls and traps that come with these claims.
Got it. And then kind of wrapping up here, getting to the end of our time. But Jonathan, exclusions in a commercial crime policy that you might typically see and that a business owner may not be aware of.
Bribes by owners and partners are excluded from most policies. Sometimes that'll surprise them. Oh, I can't commit a crime and then file a claim. No, that's most people understand that, I think. But legal expenses from crimes are not covered. Basically anything relating to a crime from an owner or partner or somebody who's in charge is obviously not going to be covered. Government actions like seizure or destruction of property are excluded. Typically, claims brought by third parties for losses resulting from a crime are typically not going to be covered. Inventory shortages, that's not going to be covered. Loss of data and intellectual property sometimes will come up, or trade secrets. Those are also not going to be covered under a crime policy. That's going to be typically covered elsewhere. A lot of times that's something that gets picked up under the cyber policy. So that's the exclusions.
Got it. Got it. All right. We are coming right to the end of our wire. Gentlemen, thank you very much for your time today. We appreciate it. The audience appreciates it. For the audience, if you are looking for more on-demand videos for continuing education, please look to financialpoise.com. And thank you all for participating today. Appreciate it.